This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
Now I have the pleasure of introducing Glenn Barger once more, who will then introduce the same colleagues from the morning ethics presentation. Glenn is now a full-time mediator at ADR Services after almost 30 years litigating the same types of cases he now mediates, including bodily injury, professional liability, real estate, business disputes, landlord-tenant, wildfire, labor, and construction matters. He is also a former president of the Association of Defense Counsel of Southern California, where he worked closely with the Consumer Attorneys Association of Los Angeles to create the Joint Civility Conference, and along with the leading judges of the Los Angeles Superior Court, the Settlement Conference Program for the Personal Injury Courts, where a plaintiff and defense attorney jointly conduct settlement conferences at the courthouse. He now brings his experience actually litigating and resolving these cases to the mediation table to help the parties resolve their cases. Glenn, back to you.
Thanks again, Hayward, for the nice introduction. And also thanks to everyone who has stayed throughout the day and for others who've now joined us this afternoon. Truly, as we head into the last 2 hours of this presentation, I wish we could all meet up at the bar afterwards in person and get caught up and even meet some new people. And I hope that happens in the very near future. For now, though, I'm very happy that we can go forward online. And it is my pleasure to introduce my co-speakers today again. All are truly leaders in the litigation world and are now already off to very successful starts as mediators at ADR. First, David Casselman. David enjoyed over 40 years as a successful litigator representing both plaintiffs and defendants in major hotly contested cases. In 1 year, he secured 2 of the top 10 largest verdicts in California, one representing a plaintiff and the other representing a defendant cross-complainant. Over his career, he tried and won a wide variety of cases spanning several specialty areas, proving that trial skill is its own area of expertise. Along the way, he was elected by his peers to serve as president of the LA chapter of ABOTA, and then later served as president of CalABOTA, which includes all of the California chapters. But the recognition he would tell you values most is the Los Angeles chapter's highest honor, which is when he was selected for their Civility Award. Next, I'm pleased to introduce Jake Courtney. Jake was admitted to the bar in 1988. He spent 32 years trying cases for injured plaintiffs. He tried over 40 cases to verdict in both state and federal court. He's proudly served as the president of the LA chapter of ABOTA as well in 2018, leading it to be selected the chapter of the year by National ABOTA. Currently sits on the boards of both CalABOTA and National ABOTA. He's a member of the International Society of Barristers, and in 2020 was selected for membership into the International Academy of Trial Lawyers. This is an organization that's limited to 500 fellows and features members from 40 countries. He's tried a diverse set of cases that included mass tort matters, medical negligence, products liability, business disputes, and bad faith claims. Finally, last but not least, is Patrick Kelly. Pat, as many of you know, is a former president of the California State Bar and the Los Angeles County Bar Associations. For 35 years, he was a member of the executive committee and was the Western Region Managing Partner and Director of Litigation for the international law firm Wilson, Elser, Moskowitz, Edelman, and Dicker. He's a voting member of the California Judicial Council and has been honored by membership in the American Board of Trial Advocates. He's also a fellow of the International Academy of Trial Lawyers and has received numerous awards for his leadership in the legal and professional community. He's currently a mediator and arbitrator at ADR here in Los Angeles. As some of you know that we're here this morning, but we think there's a lot of new participants this afternoon. Pat's going to lead us off again with a discussion of the California Professional Rules of Conduct, which went into effect in November of 2018. We think it's important to go over those rules again because obviously of their significance, and then also just to put our discussions into context as we move forward this afternoon. So with that, I'm pleased to turn it over to Pat.
All right, thank you very much, Glenn. And thank you everyone for joining us this afternoon. First, I need to launch the PowerPoint here. Okay. All right, can everyone see that? Jake, Dave, can you see that?
No, I can't.
All right. All right, let's try that.
There we go. Yeah, you're good.
All right, thanks, guys. Sorry, folks, for that brief delay here. All right, we're going to talk this afternoon about selected ethical issues. I'm going to have to go through it very quickly, so please forgive me for speaking quickly. But in 2018, under the leadership of Justice Lee Edmond, new rules were put in and adopted by the Supreme Court that conduct attorneys in California. I'm going to go through those quickly. There's a lot to cover, so hang on to your seats. But let me mention that I have made the PowerPoint that I'm using this afternoon available to ADR services, and you can get a copy of it either from them or from me. I will give you my email address in a second, and I'd be happy to provide it. And now with that brief introduction, let's get into it. And by the way, this may be the most important lecture you go to this month. The reason is most attorneys don't fully understand that there is an ethical duty to be fully familiar with these rules. And lack of knowledge of a rule is no excuse for a breach of the rules. So it's to everyone's benefit to have reviewed these carefully. So here we go. As I said, they were effective in November 2018. First major change in the rules since the 1980s. They're located on the California State Bar website. You should write that down, calbar.ca.gov. If you navigate around it, you will find not only the rules, but tables that relate back to the old rules, history of the current rules, and also various ethics opinions and editorial comments with respect to the rules. So calbar.ca.gov, remember that, and you can navigate to the rules from there. All right. The new rules are 69 rules that replaced 46 old rules. 42 of the new rules state concepts that existed under the old rules that are basically common sense concepts, but 27 of these rules are entirely new to California. Please note, these rules do not adopt the ABA model rules of professional conduct. In fact, California is the only state that determined not to adopt them. But as I mentioned earlier, for ease of comparison between the new rules and the ABA rules. The new rules adopt the ABA numbering scheme. Every attorney in California is ethically bound to review and adhere to these rules. Failure to comply can result in discipline, disbarment, disqualification. And since I spent most of my career defending lawyers, it also can result in litigation against an attorney who's breached those rules. Today's discussion will focus on an overview of it. It's not a substitute for your careful review of the individual rules. At the end of this, if you have any questions or need more guidance with regard to the rules, please feel free to call on me at pkelly@adrservices.com. Also, as I mentioned, ADR Services has a copy of these PowerPoints they can make available to you. Let's talk about organization. The new rules are organized into 8 chapters. The first 2 chapters deal with the function and purpose of the rules. The second chapter deals with terminology. That's Rule 1.0.1. Very important that you spend time with that because, as we'll note in a second, there are many defined terms within the new rules. The way they're broken down is basically by what is happening with the lawyer as an individual. Lawyer-client relationship, Chapter 2 is duties as a counselor. Chapter 3 is duties as an advocate. Chapter 4 deals with transactions with persons other than your clients. Chapter 5 deals with law firms and associations. 6, public service entities, a new section. 7 is information about legal services, also a new section. And finally, Chapter 8, which may be the most important of them all, is maintaining the integrity of the profession. We'll be talking about the consequences of misrepresentations under that section. Taking the sections now, I'm going to focus on the more important of those rules and also rules that might particularly apply to attorneys dealing in mediation, situations you come into when you're working in the mediation context. As I mentioned at the outset, the purpose is to regulate the conduct of attorneys. Violations of the rules do not in and of itself cause an action for damage, but it can be evidence of a breach of duty. In short, you could lose litigation for malpractice. Terminology, I mentioned earlier, some key terms you need to have defined for you are belief, informed, consent, knowingly, reasonable, screened, and substantial. Those are absolutely key terms that are used as words of art in the rules. So make sure you review the terminology carefully and the definitions before launching into the rules. Now to Rule 1.1, competence. Lawyers must be competent. What does that mean? You need to have the sufficient mental, emotional, and physical ability and learning and skill to undertake a representation. Now that can be provided, if you don't have it, by associating a lawyer who does have it. In fact, it's your duty to do that if you undertake the assignment, and also by research on the subject to make yourself an expert. Now, this rule is a trap with technology, because in this day and age, lawyers are expected to have at least a fundamental knowledge of technology and the ability to work with it. That has been heightened dramatically by the coronavirus, which has created a booming market in virtual technology, depositions, mediations, court appearances, meetings, conferences with clients, all now relate to technology and as often as not are done over the internet. So what is engrafted onto this competence requirement is a requirement to be technologically proficient. Another thing to avoid is dabbling. What do I mean by dabbling? That means going in and out of cases, not really being an expert at a case, but saying you can handle it. Personal injury case, for example, you may feel you have the competence to handle it, but if it's one case that you have in a year or a month, you need to make sure that you're technologically proficient in all of the issues in in personal injury to handle a case. And the enemy of competence is epistemological error, which goes back to a Greek battle. But what it means is this: you don't know what you don't know. And that's the biggest risk attorneys who dabble take, is they don't know what they don't know. And that which you don't know is what will get you sued and what will damage your client. So remember that, avoid dabbling. Next is communication with clients. Clients need to have the ability to make informed decisions with regard to their case. Therefore, the new rule 1.4 dealing with communications with clients relates to that very issue, making sure that you communicate completely and frequently with clients so that they are prepared for the matters in which they must give informed consent. Simple example, when you're with a client in a mediation, you need to have explained all of the factors involved in reaching a result so that your client, when they sign a settlement agreement, has indeed gained sufficient knowledge to make a good decision with respect to that. You also have a duty to advise. Someone has their microphone on. That's interfering with the lecture. You have a duty to advise any limitation in your conduct or your expertise. Lawyers who claim to be experts in areas that they are not are a sitting duck for a malpractice claim and a disciplinary proceeding. And what do you think is the most common cause for complaints against lawyers? I know if everyone here could raise their hand, more than half the room would say returning phone calls, and that's right. The failure to return phone calls and the failure to give your client that level of understanding of the matters that affect them to allow them to make informed decisions. Next is confidential information of a client. That is particularly important in the arena of virtual appearances and email, and of course, hacking. A rule you need to, or a code section you need to be aware of in addition to the rules is Business and Profession Code section 6068, which carefully defines all of the duties of an attorney. So whenever you read the rules, you must also read that, because it prescribes what duties attorneys have. It requires an attorney to maintain inviolate the secrets of their client. And that brings us right into the arena of technology. The Pennsylvania Bar Association has issued a opinion on technology and attorneys, which has been adopted generally as a standard of care nationally, that says that an attorney working from home or another remote location is under the same obligation to maintain client confidentiality as is the attorney when working in a traditional physical office. What does that mean? It's as if you took a briefcase into a cafeteria and by accident left it there. Your worst enemy got a hold of it and published what was on it on the front page of the Los Angeles Times, to the detriment of your client. In this case, in the case of technology, rather than leaving the briefcase in the cafeteria, you leave the briefcase available for hackers or others to find on the internet. Therefore, attorneys have a duty to make sure they have active virus guarding and whatever other techniques are available to protect information, passwords, all of those words we've had to learn, many of us, since coronavirus took over our community. So remember that Pennsylvania Bar Association rule and the standard of care with regard to preserving client secrets you're now confronted with. Conflict of interest. Again, in a modern world where people are working from home, not interacting frequently, the opportunity for a conflict of interest to arise is even greater. Any large firm needs to have a conflict checking system, but even a small firm is held to the same standard of not making a mistake with regard to conflicts. Rule 1.7 creates a new formula for determining whether there's a conflict and what you do about it. I'll read it since it's actually relatively simple to state, but difficult to apply under Rule 3-310. The rule says that where there's a direct adversity to another current client in the same or a separate matter, you have a conflict. Or if there's a significant risk that undertaking a representation of a client will materially limit your ability to represent another client. Let me give you a simple hypothetical that brings it all home. If you learn something, if you are representing client A and B, and if you learn something from client A that would be important to client B in their representation, you must disclose it to client B. So how do you resolve that conflict? You deal with it up front by remembering that if you know something from client A, you have to disclose it to client B. You can get waivers, you can get knowing informed written consent, but if the issues are closely enough aligned, even a written consent won't protect you. In other words, you shouldn't be representing adverse clients in one piece of litigation. So remember that and review Rule 1.7 very carefully. It is a frequent source of disciplinary proceedings and a very frequent source of litigation against law firms. A new rule, sexual relationships with a current client. It used to be that there was a multi-pronged test to determine whether or not it was improper and a violation of the rules to have sexual relationships with a client. A bright line rule has been put in place of that. Rule 3-1.0 provides a bright line rule that prohibits sexual relations with a client unless the client is a spouse or registered domestic partner, or there was a pre-existing relationship before the lawyer-client relationship. Rule 1.10, imputation of conflicts of interest, is important in law firms. It provides that if your partner or associate has a conflict, it can be imputed to you. Now, there's a knowing requirement. And also this rule, for the first time in California, recognizes ethical screens where you might be able to wall off a given attorney from any involvement or contact with a given case, and in that way be able to continue to handle the matter. But it's very fact intensive, it's fact sensitive. You need to carefully review the cases that exist under this ethical screen provision if you're going to try and do that. The cases I have cited here, National Grange, the Kirk case, and Hendrickson, all are cases where in specific fact circumstances, an ethical screen was allowed or not screened. Although it was called by another name in those days, it was then called a Chinese wall. All right, next, special rules where the organization is a client. This is one of the rules that is breached almost whenever an attorney undertakes a representation, a deposition. Generally, when you're engaged to defend an organization or represent a plaintiff organization, you represent the organization, not the individual who's being deposed. So I know that I've often heard in a deposition, I represent this witness today in this deposition. That may be true, so long as you have had a prior discussion with that witness, pointing out to them that you are representing them for purposes of this deposition to protect them, but you are not representing them for all purposes because you represent another person, the organization, the employer, the company, the other party. You represent that person. And to the extent you learn anything in this deposition from the deponent, you have a duty to report it to that other person you represent. And you can find a greater refinement of this proposition under the Business and Professions Code section 6068 I reported earlier. But remember, there are specific rules as to when an attorney must report up the chain of command what they learn in a deposition, and the way you must handle it is having a clear discussion with the deponent before you start the deposition as to who you represent and how you're going to have to report up the chain of command whatever they tell you. So I urge you in your deposition practice to read Rule 1.13 carefully. Next rule, 2.4, a lawyer is a third party neutral. I put this in here to present a cautionary note for the neutrals in the audience. First, a third party neutral assists two or more persons who are not clients. So you don't develop an attorney-client relationship. But there are other rules that you as an admitted attorney still have to be wary of. Misrepresentations to the court, misrepresentations to other parties. All of those could subject you to discipline. So being a neutral doesn't insulate you from potential discipline for misrepresentations. Candid towards the tribunal. This is a tough one. It replaces old rule 5-200. I think we all know as a common sense matter, you don't want to lie to a judge. That is not only bad practice, but could get you in a lot of disciplinary trouble. This rule prohibits specifically knowingly making a false statement of law or fact to a tribunal, a judge, and it also has a burden to correct a misstatement previously made when you learn what the truth is, and it requires that you proceed to do that correction even if your representation has terminated in the case. I know it's common sense to everyone here that it's wrong to misquote a statute or decision or authority to the Court of Appeal when you're making an argument. The teeth that this puts into it is you can be disciplined for doing that. All right. The next rule is truthfulness in statements to others. This is common sense, but it's a new rule that imposes a disciplinary standard for misrepresentations to third parties. This comes into the question of puffery and representations that you make to other attorneys and that you make to the mediator in a mediation. It's a disciplinary violation to make that misrepresentation. Now, what is a misrepresentation? What is puffery? There are lots of cases on that subject, and you could ask Jake Courtney that, who's an expert on that particular area. But the simple fact of the matter is, whenever you're playing fast and loose with the facts in a mediation, you're walking up to the line. And it will affect you not only creating a potential ethical problem, but it also will affect you with your client because you're setting them up for potential problems later. For example, a fraudulent representation of fact upon which the other party relies in making a settlement can result in that settlement being invalidated at the option of the other party in the future. And there's a complication of that with mediation confidentiality rules, but nonetheless, lying to the other side is a bad idea, can cost your client a lot of money and time and trouble, and also can cost you a disciplinary violation. For further elaboration on this rule, you should look at Business and Professions Code 6106 that makes counsel subject to discipline for acts of moral turpitude, dishonesty, or corruption. Communications with unrepresented persons. This one is a trap for the unwary. Unrepresented person can be a client calling you to interview to see if you'll take their case. It can be a witness that you're talking to in litigation where you're preparing to go to trial. It could be any of those things, but there are specific rules here as to what you can or cannot do. Rule number one is you cannot misrepresent who you are and what your interest in the case is. You can not call a witness in Texas and saying that I'm just checking out some facts on a case if you in fact represent one of the parties. That witness is entitled to know who you represent and why you're calling. And I can tell you from having defended firms in court that a terrible shot to the credibility of your witness will be if another witness says that your witness called them, did not tell them who they were, tried to get admissions from them, only to find out later that they were an attorney who was going to be damaging them in their own litigation. So remember, you cannot misrepresent to any third person who you represent or why you're talking to them. Responsibilities of managerial supervisory lawyers. I put this in because it's a new rule that collects together what many of us who are managing partners or supervisors assumed all along, and that is that you have a duty to make reasonable efforts to ensure that all the lawyers who report to you or are working on a case under your supervision are complying by all these rules. They're not misrepresenting. They're being careful of protecting the client's secret. They're not representing their competent when they aren't. They aren't dabbling. Those are all your duties when you're the supervisor, and you have to make reasonable efforts to ensure that all those who you supervise are doing that. And also it will make you vicariously responsible for the violation if you ratify the conduct or if you order it. So it's a truly difficult area, and I urge you to read this rule if you have any management or supervisory responsibilities. But it's a two-edged sword in a way, because the subordinate lawyer also picks up responsibilities under new rule section 5.2. It provides that they have an independent duty to comply with the rules, and if they believe the senior lawyer's proposed resolution of an issue or a problem violates the rules, they have a duty to communicate their disagreement to the lawyer. And if at the end of the day, they feel it's an irreconcilable conflict between their supervisor's position on the rule and their duty to fulfill the rules, they have to act in the best interest of protecting the public by not doing something that they believe violates the rules. And if they do something they believe violates the rules, they have no protection in a disciplinary context. Saying that someone ordered you to do it will do you no good. Next, membership in legal services organization. I included this not to go in detail through the rules, but just to advise those of you who do pro bono, who are active in legal services organizations, who work with public counsel, or any one of a neighborhood legal society, any of those organizations, there are special rules that apply to you that may, in a given circumstance, allow you to continue a representation, even though technically it's in conflict with other representations your firm has. So I urge you, if you're in that arena where you're doing pro bono work or belong to any of those legal services organizations, that you review rules 6.3 and rule 6.5. Communications concerning a lawyer's service. I would think this is common sense, but there's a specific rule on it now that says false or misleading communication about a lawyer or their services is a violation of the rules. Misconduct, Chapter 8. You could spend a day just on this alone. It identifies specific instances of misconduct for an attorney. Such thing as engaging in conduct prejudicial to the administration of justice, dishonesty, fraud, intentional misrepresentations. Here's an important one: state or imply an ability to improperly influence a government agency or official. Puffing, that means puffing to a prospective client that you have an in with the LA City Council could indeed constitute a violation of this rule, particularly if it's not true. But just merely making the representation can be a basis for misconduct. If you're in marketing or doing those kinds of functions, which virtually all lawyers are, I urge you to carefully review Rule 8.4. A couple of other resources I want to talk about. Rule 8.4.1 prohibits discrimination, harassment, and retaliation. There was a former rule, 2-400, that prohibited that, but generally required some kind of finding that you had engaged in that conduct before there could be a disciplinary action taken against you. That has now changed. Merely the allegation can require self-reporting. I urge you, particularly those of you who are in management, hiring or firing both resources and personnel, I urge you to carefully review Rule 8.4.1 and the comments under it. An important additional reference I've mentioned several times is section 6068 of the Business and Profession Code that defines the statutory duties of attorneys. It is read into the rules of professional responsibility, so it provides yet another and often higher bar that you have to adhere to. You must review that section carefully if you practice law in California. And remember, you're held accountable for knowing what those rules provide. It will be no defense to say that you didn't know that the rule prohibited what you just did. What do you do if you have a problem you can't answer the question? Call the ethics hotline of the bar at 415-538-2148. Also, you can request assistance over the internet under the calbar.ca.gov website. And also for additional references, such as ethics opinion of the California State Bar Ethics Committee, you can go to calbar.ca.gov and it will link you to those opinions. Also, local bar associations, many of them have ethics committees that can give you opinions. Finally, a comment on civility, which I'm going to put into the general fabric of ethics violations. I've cited here 3 cases, and one in particular you should note is Martinez versus O'Hara, the center case where the court found that the conduct of an appellant in using derogatory language towards a female trial judge evidenced gender bias, violated Business and Professions Code section 6048, and reported him to the state bar. In Brigantine versus Chow, the council felt that being over complimentary to a trial judge, calling a woman attractive, was irrelevant and sexist. That was Brian Curry, who chairs a new committee on civility that's being sponsored under the California Lawyers Association. So be aware that violation of civility can morph into actions contradictory to the administration of justice, and actually create a violation under Section 8 of the new rules. I've really kind of run over my time. There are no time for questions, but if you want to put one on the chat, we'll try and get to it at the end of the section. And again, I have made this PowerPoint available to ADR services, and they, I'm sure, would be happy to make it available to you, or you can receive it directly from me by dropping me an email, pkelly@adrservices.com. Thank you for your attention, and remember, you are responsible for knowing what these rules say, whether you've reviewed them or not, once you're an attorney in California. So take 2 hours after today's lecture and at least read through the rules carefully.
Thanks, Pat. There we go. So Jake, we can't have a presentation in the middle of this pandemic without at least a discussion on how COVID has changed mediations.
Yeah,
Pretty apparent.
you're right, David, but I think we're a little out of order. I think Glenn's next.
Oh, is he?
Yeah, Glenn's next.
And I have a question for Glenn.
Yeah, that'd be great.
All right.
Glenn, clients of our attendees are always looking to their attorney for advice and recommendations of mediation, including settlement. So how do you work with attorneys as a mediator to ensure that clients are on board with offers and reduced demand, as well as the final term of settlements, to comply with the ethics requirements that the clients who have settlement authority need informed consent? How do you deal with that?
Thanks, Pat, and thanks for going over the rules again. First, let me say, with the miracle of Zoom, I do a lot of these mediations online every week, and I am particularly impressed that a number of my friends have been able to figure out, even at a webinar, how to heckle me when we're not in person. So I appreciate that. As a practicing attorney, as well as being married with kids for almost 30 years, I don't recall which I learned first, that my client has ultimate authority as to whether to settle a case, or that at home, my level of authority to make final decisions is also extremely limited and well below that of my wife, kids, dog, and lately, especially the Amazon delivery person. As attorneys, if we were in person today and I asked you to raise your hands as to whether the majority of your clients look to you for guidance and advice based on your particular expertise as to when to settle, including specifically asking you, should I settle this matter for this amount? I believe the significant majority, if not all of you, would raise your hands. In fact, many clients on both the plaintiff and defense side probably ask you these questions early on in your representation, if not the day of your first meeting, and then continue asking throughout your representation. However, whether to ultimately accept a settlement as final is up to the client. I believe it is, though, extremely important strategically and also ethically to discuss the potential for settlement with your client from day one of your representation, and then throughout the handling of your matter, and certainly before and during any formal settlement discussions that you have, as it's a good idea that you continue to discuss your client's expectations and also ideally attempt to manage them to prevent any issues down the road for you. I'd also suggest that you utilize the services of the mediator once you have one involved to help with your client as necessary throughout the settlement process. I think this is especially important as you go forward with Zoom mediations, as you and your client may not be in the same physical location. So it's even more important to make sure you confirm your actual settlement authority before and during the mediation, as well as in writing when possible. I think most of you now have used the Zoom platform and probably done Zoom mediations, but it's really easy. Even though people are in separate locations, we place everyone in their own room, just like we would in a normal mediation. And then what I do after I've had a chance to discuss the case with one particular side is I ask them if they want me to step out of the room so they can talk privately. And then I just ask the attorney to text me when they're ready for me to come back. And then we can confirm their authority. But I think it's especially important, and I think it's also ethically required that you be very clear with your clients as to what authority they're conveying with you, especially as to final settlement. From the beginning of a case, attorneys should advise their clients about alternatives to traditional litigation. I know a lot of you trial hotshots absolutely just want to take the case to trial, and some of your clients do as well. But it is still incumbent upon attorneys to discuss potential settlement opportunities short of trial. Interestingly, it's actually been surprising to me, even in California, how many litigants I see on a daily basis at mediation who have no experience having attended a mediation or a settlement conference. So it is important that you discuss that with your client. ABA Rule 3.1.1, which again isn't binding in California, but the courts will still look to it, provides that a lawyer should consider and discuss with the client promptly after retention in a dispute, and thereafter, as relevant, possible alternatives to conventional litigation, including settlement. However, the decision whether to even pursue settlement discussions belongs to the client, and therefore a lawyer should not even initiate settlement discussions without express authorization from the client. Although the rules of professional conduct that Pat just went through don't specifically state these requirements I just quoted, the new rules do cross-reference the old rules right at the beginning if you print it out or look at it online. And regardless, in California, I think we get to the same place through Rule 1.1, which provides that an attorney must provide their client with competent representation. I think clearly that includes discussing potential resolution. Further, Rule 1.4 then provides communication with clients, includes keeping the client reasonably informed about all significant developments. The key word being significant developments. And again, I think discussing settlement and settlement discussions is certainly a significant development. 1.4.1, communication of settlement offers. provides that all amounts, terms, and conditions of any written offer of settlement must be promptly communicated. Also, the comment to that section states an oral offer in a civil matter must also be communicated if it's a significant development under 1.4. As a result, I really don't think there's any dispute that settlement offers should be communicated and, when possible, communicated in writing to avoid any issues down the road. I think many of you have heard the war story, hopefully haven't actually dealt with this situation where your client has made it clear they want a certain amount of money and an offer comes in that is significantly below that amount. Later on, it's then increased by some small amount, say $500, obviously well less than what your client's seeking, but the new offer is not actually conveyed to the client. The case then goes to trial. There's a defense verdict, leaving the plaintiff with nothing and exposed to potential costs and even fees. Having represented attorneys and now mediating these types of cases, it's not a comfortable place for any attorney to be situated. So even though you may get a small increase in offer, you know it's not going to be accepted. It's important to convey that to your client. I would say clients that I see typically do smartly defer to the special knowledge and skills of attorneys that are representing them, particularly with respect to technical and legal decisions. But it's important to note that ABA Guideline 3.1.1 also provides that during mediation, attorneys must reasonably consult with their clients, respecting the means of negotiation of settlement, including whether and how to present or request specific terms. I had a landlord-tenant case a couple of weeks ago where both sides, and there were multiple defendants, probably had a list of maybe 20 different specific terms. So in addition to the monetary issues, there were specific terms that their clients were adamant about. And so it was important that those issues be discussed as well. A couple issues to be aware of: even if there's a potential for prejudice, an attorney may seek withdrawal as counsel based on the client's approach to settlement, including if the client insists on pursuing an objective that the lawyer considers repugnant, illegal, or places an unreasonable financial burden on the lawyer. A couple other issues to cover. I've handled a lot of professional liability matters, and I'm mediating those cases. And it should be noted that in professional liability policies, and I think this was one of the questions from this morning that we didn't get to, they do typically have consent provisions as well as related hammer clauses. And if you practice in this area, you're familiar with what those are. But under the consent provision of professional liability policy, which is different than a GL policy, the actual client must specifically consent as to any settlement, as it could impact their professional licenses and subject them to reporting requirements under their licensing agency. Here, I would suggest that you obtain written consent in advance of the mediation if possible, and then update it as necessary. And again, that should be in writing. And then if the numbers go up, you should seek additional authority. Some other issues to be careful of when there's cumulative situations or potential insurance conflicts. I think that's a time where you want to get your mediator involved, even in advance. Do a pre-call so that you can alert them to the issue so that you're not put in a difficult situation. And sometimes it's even necessary to separate insurance carriers from their insured so that these issues can be discussed. Another type of case I've seen come up and can cause issues is where there's multiple injured plaintiffs. For example, multiple people in the same car. I've had bus cases where there's multiple people injured and there's a finite amount of money available to settle the case, and everyone must agree to it. And there may be an attorney who's representing multiple plaintiffs in that situation. And I think there it's especially important that you discuss any issues with your clients and confirm their authority to settle the case for material reasons as to why their amounts are different, as again, that could put you in a difficult position down the line. Finally, I'd mentioned, Pat referenced informed consent is important in the new rules. And it is important that you make sure you do have informed consent from your client. TBI cases, I think, are particularly risky where there's a seriously injured plaintiff, and or I've seen some plaintiffs that are seriously medicated at mediation. And I think it's important that either the attorney get a guardian involved, or at least have something in writing, maybe from a doctor, confirming that they do have the capacity to make a decision and go forward with the settlement. Again, as the mediator, I actually think it's my responsibility to raise these issues and discuss them and make sure there is informed consent. I'd probably do that privately with the attorney first, but I don't want to get to a situation where there is an issue with the settlement down the road. So those are my overall comments. And maybe just quickly to the other presenters on the panel, with all your experience litigating and settling these cases as practicing lawyers, now as mediators, how do you look to the actual parties for settlement authority? And is there any advice you have for attorneys as to how to approach settlement authorities with their clients, including in class actions and mass tort cases? David, did you want to jump in? Do you have any comments?
Well, this is a strategy question for the lawyers, of course, but from my perspective, I appreciate the candor of the lawyers talking about where they are, where they'd like to be, and where they would probably be willing to go. I don't expect them to give me their bottom line, so to speak, but it's good if they share with me what kind of flexibility they have. That doesn't mean we just jump to their worst case scenario to settle the case, but it helps me know what we're dealing with. And then once I hopefully have that kind of confidence, it gives me a lot greater comfort that I know where I have to put pressure and what pressure I have to apply. And I think in general, candor with the mediator is the best possible strategy. Obviously limiting the mediator from sharing things that you don't want shared, and urging positions for you that you want to have urged. And I think that works best, in my opinion.
Glenn, I have a thought on that, but there's one thing I want to make sure that we advise this audience of, and that's the the new code section, the Code of Civil Procedure section 664.6 that went into effect on January 1st. That provides that an attorney can sign for a client. That often was a difficult time in mediations when there was no one to sign on behalf of the client. 664.6 provides now that attorneys and in some cases other agents can sign a settlement agreement on behalf of a client. Now it creates a trap, obviously, for attorneys. In fact, I want to read Section D to show how much the legislature loves lawyers. In addition to any available civil remedies, an attorney who signs a writing on behalf of a party pursuant to subdivision B without the party's express authorization shall, absent good cause, be subject to professional discipline. So I have to put on my old defend the lawyer hat and say a safety tip is, even if you write it on a cocktail napkin, you've got to get a written authorization from your client to sign an agreement on their behalf. An email, some way of communicating that you can demonstrate that you actually had that authority. That's my tip.
And as the Cassell case demonstrates, even if you have their signature on a settlement agreement, it doesn't necessarily protect you completely.
That's true.
Right. And that gets us into ratification, Glenn, too, where, even if there is some dispute, if the client takes steps to ratify that they have accepted the settlement, it may be upheld, but everything's going to be kind of facts and case specific. So, and going back, Glenn, to your first question, which is, I used to always, when representing clients, would try and talk to the mediator because I think one of the roles of the mediator is to help the client understand the process and understand limitations and things of that nature. But oftentimes when I had good client control and a good relationship with my client, I would call the mediator in advance to let him or her know that this isn't the case where I need you to spend a lot of time with my client. And so now as a mediator, I try and do that. I think time is very important. And one of the earlier speakers today talked about the use of time and how as time is expiring, you tend to see things get to where they're going to go. But I don't believe in wasting time. I believe that, there isn't a cookie cutter approach to how you approach these mediations, and knowing as much as you can, not just about the facts, but about the participants, can help you use your time effectively to effectuate a settlement between the parties. And so consent is a big issue of that. And I did a lot of medical malpractice cases in my early years as a lawyer, and now as a mediator, I'm mediating those cases. And as you said, those policies where the doctor has to give either her or his consent on authority to settle it as you cross certain thresholds is really important. And knowing that in advance, the mediation can really help frame the discussion so it's a meaningful day. Even if cases don't settle, we want them to be meaningful, but you want to give yourself the best chance of settling the case by having all the relevant facts.
All right, well, I think we probably need to move on to the next issue. So,
All right, I jumped that gun before because I was just so anxious to hear Jake talk about the ethical issues that COVID has raised for us in Zoom mediations as opposed to our traditional mediations. So don't hold me in suspense any longer, Jake.
This morning I gave you the history of puffery. The history of Zoom is much shorter. What you need to know that in December of 2019, the December of 2019, not that long ago, 13 months ago, Zoom had exactly 10 million subscribers. By March, the first real month of the lockdown and the shutdown in COVID, it jumped to 200 million subscribers. It's changed all of our lives. COVID has had an effect on the way we practice law and the way we mediate cases, but it does come with it certain pitfalls. And Zoom isn't the only platform. Zoom happens to be the one that ADR uses, and I think it's a terrific platform if you participate in a safe way and you participate by protecting your clients. When you set up a Zoom mediation with ADR, we make sure that every Zoom is password protected. And the overall theme here of ethics and protecting your client in this talk is going to be protect, 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 protect. I can't say it enough. We live in a different world. I mean, I'm here at the ADR office today and I'm on my laptop and I have my iPad and my phone within inches of me, and I have a different password for each of those devices. You have to protect your client, and the way to do that is to be very, very careful in how you go about those things. Just to dig in a little bit about the Zoom mediation and some ethical concerns. One of the safety precautions that we put in place is that you can't just enter the Zoom. The mediator or an ADR staff person has to invite you in to join the room. This is an extra step of safety, which I think is very important. It's important also then that when you do enter that room, your screen says exactly who you are. You can see right now that my screen says Jake Courtney, but with a click of a button, I can rename myself. And magically I'm Cher. I'm clearly not Cher. Love Cher, saw Cher in concert in Vegas a couple years ago. I want to get back to seeing concerts. But I had a mediation the other day where the defendant doctor was using his wife's device and it had her name. And she had a different last name than the doctor. And I didn't know who that person was. And so I think it's important that you use that screening process to make sure you have all the right parties and only the right parties in your Zoom. that raises the other question, which is everybody seems to be home. And when you're home, you have to know what's happening around you, and you have to protect attorney-client privileges and the mediation privilege. It's important that you don't Zoom from public places. It's important even within your own house. You may have a roommate who's not related to you, who you have no privilege with. And you got to be aware of that and create a safe environment. Again, this ties all back to the rules that Pat went over again this afternoon. And Pat, thank you again for doing that. That was a chore to have to run through a lot of rules in a short period of time. But I think for the people who weren't on this morning, it was helpful. But I think it was also helpful for the people that heard it twice, because, it's a lot of information to take in. And certainly you can go to the State Bar website and see those rules, and you can see how they're interpreted. But I think it's very important that everybody knows those rules, because it helps all of us practice law in a way that's to the benefit of our clients. It's interesting in that Pat also talked about technology and what it is. And he gave the example of leaving your phone in a Starbucks. We don't get to go in the Starbucks anymore, but I think it's important, again, that you realize, and I want to emphasize, that you have to protect everything as if it was at your office. A lot of the home computers that people have at home don't have the same cybersecurity installed that you would at an office, whether you have a small legal office or a giant office. That security is going to be greater, and you got to know what your security system is, so that you aren't subject to malware and you aren't subject to a virus. And so everybody should take the time to know what that is and make it work. I'm changing my name back.
Jake, while you're taking a breath there, I have a question for you that was recently asked of me. Many people who have stayed in hotels, you recall what those things are, that the places you used to go to before COVID-19?
Yeah, I remember those.
Right. They use open source internet for Zoom calls.
Right.
My advice to them was that that's theoretically a violation of the rules if that information is pirated. Do you have a thought on that, or do any of the other panelists?
It's a great question. I've actually been at a hotel where we've then gotten a warning or an alert that their Wi-Fi has been compromised. And it's hard, because lawyers used to travel and you have to get work done. And it again raises some of those ethical issues that you talked about both this morning and this afternoon, which is, at what point do you have a duty to report that to your client? Again, I think it's kind of fact specific, and I think, and again, I'm not the expert on tracking that footprint of what was seen, but bringing in a cybersecurity expert to see what was compromised, I think may be necessary to satisfy yourself that your client's confidential information hasn't been compromised. What do you think, Glenn?
Yeah, I actually think, Pat, you raise a good point. I think it ties into the managing partner's responsibility in the ethical guidelines. I think firms probably need to have specific rules as to when you can go on to a public internet access deal. And I'm definitely not the technology person. I've gotten very good with Zoom, but I know there's a lot of companies out there that will not allow their employees to go on to public internet sites. That's why they have ways to do that directly themselves. And it's probably something law firms should consider and not use those public resources. Also, I did have to mention, when Jake was talking about passwords, I don't know if anyone else saw the story this morning, but it's still killing me. Some guy won a contest where he got bitcoins,
Yeah.
and it was on the news this morning, and it was when Bitcoin was at $5 a share. Well, those shares are now worth $200 million, and he lost the piece of paper that he wrote the password down. And he only has 10 attempts to get it right, or it's forever locked.
Yeah.
And so someone, and he's done 8 of those attempts. He's now got 2 left, or he's going to be out $200 million. I don't know about most people on this call, but that might drive me insane. So just thought I would mention it with your password protection. Make sure you're careful with knowing what it is.
Yeah, and there are ways to securely keep your passwords available to you, and certainly with something as valuable as Bitcoin or your clients' confidential information files, you better have a method in place. I know he only has two tries left. I'm sure he's tried 1111 and 1234 also. But in case he hasn't, I want a piece of the Bitcoin value if those are the code.
As perhaps the least technologically skilled, I think he should click the button that says "Forgot password."
David, is that your home screen, David?
No.
I think we should talk about arbitrations, and I think in our next section, Pat's going to talk more about differences between arbitrations and mediations. But as it pertains to Zoom, a couple of things to think about. You can see in our upper left-hand corner of your screen that we're recording this program, and that is something where this is not a privileged conversation. When you get into arbitrations, depositions, and different other legal hearings, you should be aware if something's going to be recorded, and you should know whether or not you have the right to record it. As a general rule, if you're having a conversation with your client and it's just the two of you, I would recommend you don't record it, because unless you have, again, permission to record it, think of it as a phone call. You don't want to cross over into some ethical boundaries there. As it pertains to arbitration, you might have a witness testifying from home, and certainly in a courtroom or even at a mediation center when an arbitration was taking place, you can't have someone in the room who's not supposed to be in the room. In the setting of an arbitration where the witness is at home, I think it's important to set out ground rules with your opponent and put them in writing so you know what's going to happen. And this ties into that civility component of this. A dog running through is one thing, but if all of a sudden there's another person in the room and you don't know who that is, you want to be prepared for that by addressing it with a stipulation ahead of time. You want to also make sure that a lawyer isn't communicating with his or her client by text message while they're testifying. And these are things we didn't have to think about before Zoom and before COVID, but they're very real now. And I think it's important that you find a way to solve those issues in advance. A well-crafted stipulation on anything you can think of, and these are just some pointers, and certainly not an exhaustive list, are going to help you have a civil practice, in one where you're not going to be second guessing, whether there was somebody whispering in the person's ear from across the room, or passing them notes, or sending them a text message. But I think that's a good pointer. It's also important, I think, that you get yourself in a position where the internet strength is good and predictable. Again, this goes back to Pat's question about the hotel lobby or about by the pool. Sometimes it may mean bringing your client to your office where you have a more secure internet if you are going to be talking about confidential information. This topic is supposed to involve kind of a discussion about, where do we go when we can go back to court and back to going to concerts and church and gathering in larger groups. Is Zoom going to disappear from mediations? I don't think so, because I think it provides some great pluses. One of the great pluses, I think, is that it eliminates a lot of cost and travel. Many insurance carriers are on the East Coast or in Chicago. And for an adjuster to come out here to California in a mediation, it was a 3-day trip, fly out the day before to meet with their attorney. Not sure if the mediation is going to finish on time, so you can't fly home that night and you got to spend another night. I think having a decision maker in the comfort of his or her own home, or even in their office, it provides a great benefit. It keeps costs down, which may be the difference between settling a case and not settling a case. I think that is the best plus that I've seen come out of Zoom mediations. You might have a client who can't travel. I had a case years ago where my client was agoraphobic and didn't want to leave her house. But in order to mediate the case, she had to find a way to get out of her house and eventually get to the courtroom. And it was very stressful for her. I had another client who had an elevator accident, and ADR here in Century City is on the second floor. She could take the stairs, but in some situations, the deposition at the defense attorney's office was on the 50th floor. Zoom provides, or any video conferencing provides, solutions that I think are here to stay. What do you guys think about that? Any other tips on why you think it's going to stick around?
Well, I can tell you one reason, as one who used to represent insurers, they love it. And it does not only cut costs, but creates access. And with the tools you've mentioned, Jake, of DocuSign or faxing or emailing a signature page or taking a photograph of a signature page, a lot of the barriers that affected virtual mediations right at the outset are being wiped away by new business methods. So
Right.
I believe it's here to stay. Now, I guess you can tell from looking at me, I'm older than 25. I frankly prefer face-to-face mediations because I believe those human interactions create the best environment for a mediator to try and bring the parties together. But when you look at people having to wear masks and being afraid to go to a common or a place, mediation is, virtual is here to stay, both for mediations, but for motions and for trials and clearly for depositions.
Yep, and I agree. I think masks are future for the foreseeable future. And even when we can get together, if you're in even a large conference room and you're still wearing masks, it's hard for the mediator and even the lawyer to kind of get a full and complete read on their client by interpreting body language through the face. The muscles in a person's face are very telling as to, it's kind of like being a poker player. You're looking for tells, and if everybody's wearing a mask, it makes everybody's job a little bit harder. But I also am a believer that face-to-face is the way to go. But at the same time, it allows us to mediate cases all over the state and all over the country with Zoom too. So I see both sides of that argument, and I think what we're going to see is a blend that it's again preparation and talking to your participants ahead of time as to what makes the most sense for their particular case is the key. And we can't talk about preparation enough. The preparation comes with the lawyers being prepared, but also with the mediator being prepared and being prepared to be flexible to help the parties, find that finish line.
Yeah, just briefly, I agree with those comments, and I do think that the technology is only going to get better, as it often does. And hopefully when it does, I'll actually know which company is good and can invest in it before it goes crazy, as you mentioned with Zoom. I also think that there will be hybrid approaches, and we're already doing that now, where people will come in person to mediation if they're comfortable doing that. And then some people are online, and you can still have people who are online in the room with people that are there in person. And then, as Jake mentioned, I actually have gotten so comfortable with Zoom that I'd prefer to be online as opposed to wearing a mask and not being able to see someone's face. I do think it makes a difference being able to actually see their expressions and get a feel for where they're coming from. And so there's benefits to it that are probably here to stay, but ultimately I think it's going to be a case by case basis, and certain cases or even certain parties within a case need to be in person, and there's a value to that. And then other ones maybe you can do online. And so you'll just have to evaluate it. And really it's the attorneys who know their cases better than anyone out there. And that's where you should work with the mediator to figure out what is the best approach to getting the case settled.
Right. This discussion's kind of segue naturally into our next section, which I think Pat is going to take the lead on, but it's really for all of us to comment on. But Glenn, you want to tee that up?
Well, yeah, I think the general discussion is what are ways to sharpen your mediation skills in ethical and civil ways, including in the online environment. And I'd turn that over to Pat.
Well, I'm going to take this a little bit in reverse. I'll tell you why. I know that David very much wants to have half an hour for your presentation, David. I'm going to make sure that happens. David and I used to give lectures many years ago. We're original co-authors of the Rudder Insurance Litigation Guide. So I want to give David that deference. But I do want to quickly point out something with regard to arbitration. One of my topics was going to be the difference between disclosure rules for mediations and arbitrations. I'll be very quick with that. First, with regard to arbitration disclosure rules, they're set forth in Section 7 of the California Rules of Court. They're very specific. You need to know them well if you're in arbitration. The disclosures required are, some would say, draconian. What cases you've handled, who you've handled it with, who you know, everybody you ever met, the newsboy on the corner, it's all there. And the consequence for getting that wrong is illustrated by the Monster Energy case, where an arbitrator in an organization where members of that organization had a financial interest in the organization itself. Most mediation organizations are not like that. This particular arbitrator had never represented the particular party that was the complainant in this case in arbitration, or never had a mediation with them. But there had been many other mediations done by others within that organization. And the court held that the arbitration was void because of the failure to make required disclosures, because that particular mediator or arbitrator had a financial interest in the organization that could have steered them towards favoring the party that was a repeat customer. So the lesson you need to know, whether you're challenging an arbitrator, whether you're being an arbitrator, is you've got to read Rule 7 carefully, and call me once you've read it and see if you really want to be an arbitrator. The disclosures are incredible. All right, now on to sharpening skills. How do you sharpen your skills? First, fundamental rule. You've got to approach a mediation seriously, as if it's a mini trial. You can't just sit back and expect the mediator to read a lengthy mediation brief and somehow withdraw from that the pearls of wisdom that are going to help your client in making their case. The key to sharpening mediation skills is to treat it like a for real mini trial. Make sure you know the issues, make sure you know the facts, and remember the most important rule of all, you want to make the mediator your friend. What makes the mediator your friend? If you're honest, if you're forthright, if you're well prepared, if you give them a mediation brief that shows you've thought about the case rather than trying to do a data dump on them, And the mediator then can work with you to try and present your best case to the other side. So the best way to sharpen your mediation skills, I believe, is to be well prepared, to be forthright and honest, those things. But I'll throw it open to the group. Jake, how about you?
You know what? I'm doing a little research on some of our questions. So pivot to Glenn and then I'll come back.
All right, Glenn, I'm pivoting.
I think especially in the COVID world and online, it is important to be prepared, including just making sure that you have your documents ready, or if you're going to have an expert log in and do some sort of presentation, make sure they're available, make sure your client's available, prepare your client, because again, you may not be in the same room with them. And it's important to make sure they're comfortable with Zoom and discussing things online. It's not even an exaggeration. I had a case where the brief made it real clear that there were very significant personal injuries, and future care and treatment, including surgery, was on the horizon. And almost immediately, the actual plaintiff let me know that he'd played golf in the morning and had a great day and was feeling wonderful. And I think those are the kind of things that you just need to be prepared for with your clients. Again, obviously, you don't want to coach them to say things that aren't accurate, but just make sure they are prepared for the mediation. It is different than when you're in person. You can't give them a look or tap them on the shoulder. Also, the communication with the mediator before and during and after, if it doesn't resolve, is critical, because you're not going to run into them in the hallway over coffee. So you can really discuss the case with them privately or maybe outside of their client's ear. And so you want to prepare the mediator for that, exchange cell phones so that you can communicate, talk privately if necessary, all just so you can make for a productive process and hopefully get the case settled.
The next issue I wanted to focus on is, I'm frequently asked, do you share your strategy or your bottom line with the mediator? My general rule of thumb suggestion really is that it depends on who the mediator is and how much confidence you have in them, A, to keep things secret that you instruct them to keep secret, and B, to have a knowledge of what's going on in the other room to give you good advice. So therefore, there is no one size fits all to answer that question, other than you must remember that if you give your bottom line to someone, sooner or later, that bottom line will probably pop out of the hat in one way or another, whether it's being fed back to you or being fed to the other side. So my strategy for that is have a mediation plan, know whether you're going to trust the mediator, and then judge how much confidence you want to have in sharing facts and opinions with them, and how much you trust what they're saying to you. That's my advice. David, what do you think?
I'm with you. I agree with all the comments. I think that, one of the things that's probably the most important to getting the most out of the mediation is having an understanding of what's expected. And talking to the mediator, as everybody has commented earlier, I think very helpful. Talking in advance of the mediation and kind of running through things so you can hit the ground running on the day of.
Jake, here's a tough one. Do you share or acknowledge your weaknesses with the mediator?
I do. Much like in trial, I think getting out ahead of your bad facts is helpful. I mean, if I'm now and as a mediator now, I don't want to learn at 3 p.m. in a mediation that we started at 9 a.m. that the plaintiff has, a criminal arrest or a drug conviction or something that is going to move us backwards. Maybe I don't put it in my brief as a lawyer, but in a pre-conference call with the mediator, I would like to advise and did tend to advise them of where I thought I had some problems because, I think it helps you get an honest assessment of the value of your case. And I would hope people would share with me, the good facts and the bad facts. And, we talked a lot about puffery, but, I think you still have to be honest about what your case is. And at the end of the day, you got to come to grips with your bad facts.
I think that's very good advice. Does anyone else have a comment on that before we go to the next question?
No, I really agree with that point. I think it's analogous to trial. If the other side knows about something that's detrimental to your case, you're better off presenting it yourself and lessening the attack that is coming anyways. And so just be prepared for it, and either in your brief or a phone call or at the time of mediation, discuss it with them. Obviously, if the other side doesn't know about it, keep it in your back pocket.
Well, one of the things I've always believed with respect to that is it's important, as I said earlier, to utilize the mediator to help you convince, as a mediation advocate, the other side, because they're in the other room in this day and age with the lack of joint sessions. You usually are not. And so having a credible relationship with the mediator is good to making them comfortable in advancing your cause, and admitting weaknesses rather than fighting over idiotic terms to simply make a point or appear strong doesn't make sense when you're working with a person, that is the mediator, whose goal is to help settle the case. They're not fighting you, they're with you. They want, and they will help the person that they believe is most inclined to want to settle the case and work with them to get a deal done. But having said that, I have one more question I want to put out before we turn things over to David. I'm going to throw this to you first, Glenn. What's your view on using the mediator to help your client or to help counsel convince their client that reaching a settlement on given terms would be in their best interest? How do you walk the line between being a mediator and actually applying pressure to a client when you're asked to fulfill that role?
Yeah, well, I think it is the mediator's role to discuss the case with all sides and to do that substantively. So you get into, that's why I get into the facts, the law, insurance issues, practical issues, and emotional issues early on, so that I have some credibility when I give my thoughts and comments. I have no problem, and I don't think most mediators do, having a difficult conversation with a party, whether it be an actual party to the case or when insurance is involved with an insurance carrier, including sometimes being part of roundtables after the fact when they're maybe considering increasing their offer or agreeing or not agreeing to a mediator's proposal. I do know what's going on from having spoken to both sides, and I have formed various opinions. I personally will never reach out to a party or an insurance company without the attorney being part of that conversation, or at least asking me to do it. It was a pet peeve of mine when a mediator might call an insurance person directly without getting me involved in the call. I will say that I do have a number of attorneys, though, that ask me to make a call to their client or carrier, including directly to plaintiffs, to discuss the value of their case or issues with their case. I always encourage them to be part of the call, but if they're asking me to do it, then I have no problem doing it so that ultimately we can get to a settlement.
Well, David, I'm going to direct this to you, and then you can segue into your next topic. But what often tends to happen is one side or another will oversell their bullish position of their client's position to their own client. The case is worth X, or the case isn't worth Y, or we should try this case rather than settle, or under no circumstance should you take less than X millions of dollars. And I've seen over the years that I have a perception that attorneys sometimes use mediators to help them soften the position that they themselves have taken with their own client and adjust their client's attitudes towards the settlement. What's your view of that, and how do you approach it as a mediator?
Well, first of all, the mediator's job isn't to represent their client, but if they have done that and placed the mediator in the position where they've essentially overstated the case, it's sort of a reverse Cassell allegation. They're going to necessarily have to come down in order to settle it. And I think that it's harder to get the case settled because of that. You've put your client into the position where he or she believes that a particular number is essential in order to get a fair result. And so this is a troublesome thing for a mediator, and it probably requires a separate conversation with the lawyer to get buy-in, to make sure the lawyer agrees. You never want to break down the lawyer in the eyes of the client and say your lawyer told you it's worth too much or too little, depending on the side you're on. And so you need to have the lawyer's buy-in. And if that situation arises, whether intentionally or otherwise, I think by talking to the lawyer separately and say, how do you want me to handle this? I can tell the other side what your position is. I think you know how that's going to end up, or I can just do it for you and see how it ends up. But at the same time, a good conversation with the lawyer, say, look, if this is what you believe, that's fine. But if you want my view, I think it's probably not going to work. And once hopefully you get the lawyer's buy-in, and for all the reasons you've discussed on the phone ahead of time and during the mediation with them, hopefully they'll agree with you that jointly with the client, you need to talk about the reasons why maybe it's not worth that much. And they have to figure out a way to save face so they have credibility. And hopefully you can support them in that process and get to a number where the case can settle. And you don't have to blame it on the lawyer. You can just say that other side just isn't going to pay that. Perhaps they're being unreasonable. That would be determined at a trial, but this is just the fact. They're not willing. Here's the offer. How do you want to handle that now? And try and work around the dissonance created by the client's belief that the lawyer put them in the right position.
Well, David, now that you have the rostrum and we're down to our last session, I'm going to keep my promise and turn it over to you.
And maybe I can jump in with an introduction for David. And our final topic of the day. David, I know from working with you and preparing for this presentation, you're involved in a lot of different things outside the law or even overlapping with the law. And I suspect many of our participants are interested in your thoughts about how to use their training to make a difference in the world, especially with all the issues that are going on out there right now.
This is a topic that's near and dear to my heart, and I want to thank all the people who are still with us and shift gears to something that is a little different, actually. And it has to do with kind of finding a way to get personal pleasure out of your skills and your knowledge by making changes that are hopefully positive changes in the world that you want to make. And I'd like to offer you some information about ways that can be done, and hopefully it'll change your life in ways that it has changed mine. And I can start by just pointing out there are many worthwhile charities, there are programs, there are causes that need lawyers. And obviously they could hire a lawyer, but they would prefer to have a lawyer who believes in their cause and who will help them as a participant rather than necessarily a paid advocate. And often your skills are needed and they don't even know it. And so it's good if you are one of the lucky lawyers who really enjoys practicing law. But over the years, I've learned that, we may be the lucky ones. It was a blessing and a wonderful pastime for me to be able to help people practicing law. But how great would it be to use your legal training to pursue or support other passions in your life, perhaps that you cannot fulfill in the direct practice of law? So question starting with is, are you stuck just being an attorney because that's your profession? And the answer is absolutely not. And you'll find that with a little effort, your JD is of great value and your experience even more so pursuing your personal goals. And so, what kinds of things am I talking about? Well, maybe you'd really like to help the homeless. Perhaps the environment is something that really excites you. You'd like to be able to do something. Maybe because of experiences, you're drawn to helping troubled teens or orphan children, or in the pandemic, food insecurity is a huge issue right now. A lot of people want to advocate for social change, a variety of different kinds of social change. What can we do about all those things as lawyers? And the answer is, it's really in your heart. It starts with, do you want to make a difference in the world we live in? Is there a way you can use your legal training? Yes. The next question is how. And so my hope is that we can give you some concrete ideas, steps you can take, things that will make you feel good, help your heart, and help the world. So they don't teach this in law school. This is something that I floundered with, and hopefully I can give you some of the insights I've developed, and then you can pass it along to other people as you've had similar experiences from years from now, perhaps.
Well, maybe David, you can share some of your experiences using your training outside of the law and how others might be able to find their own passion projects.
Yes, okay, great. So I think you have to start by asking yourself some basic questions. And the first one is there something you've always wanted to do, or is this a new idea? Have I thrown this out for the first time and maybe you think about it because of that? Or do you already know this is something that you've long considered, you just didn't know how to start? So the key is, how do you use your training to pursue those goals? And if you're not there yet, and you just like the idea of trying it on to see if you can make a difference, take a minute, maybe longer, look inside yourself, tap your innermost thoughts and feelings, ask yourself, if you were all of a sudden all powerful, what would you do to make the world a better place? What would you do to cause change? Now, again, the bottom line is, if you already know, great. And when you know, it's really just a matter of commitment. I'd really like to do something about X. So let's assume for the moment that you get to that point, and you know what it is you'd like to do, and talk about how you get it done, what you can do. And I don't think it's necessary, but I'm going to point out anyway, talking just won't get it done. So how do you do that? And the answer is, there are a lot of ways, but the first thing, the most important thing, is you need a plan. You have to have an action plan, because that's where change really begins. So let's start there. And then later, I want to talk to you about some ethical and responsibility concerns in the course of pursuing your passion project, because there are some pitfalls. And this is particularly important because you don't want to do anything to jeopardize your legal career as you're out pursuing your personal passions. So for now, let's start. How do you begin? And I think probably concrete world examples would help, as Glenn was pointing out, because, I could tell you, well, if this happens, then that, but I really can't help you with every possibility. And the most I can tell you I know for sure is the things that I did that caused problems or that worked well. And hopefully you can dodge some of the obstacles that I crashed into. So in my case, in my career, early on, I didn't have any thoughts about doing anything except trying to be a competent lawyer. And there was a point in time where I felt like I was succeeding in that regard, and I wanted to do something I could help. In my case, I've always had a soft spot for animals and nature. As I grew up, I learned about some of the challenges facing the natural world, and I realized things had to change if we were going to save our animals and our habitat. And so, like many people, I was troubled by animal cruelty, habitat loss, species extinction. Almost every one of these things seemed totally beyond my control. They're remote, they're in Africa, they're in Asia, they involve the oceans. What could I ever do to do anything to affect those problems? So the first rule of thumb is, when you figure out what your passion is, do not let the magnitude of the problem overwhelm you. Just calm yourself by saying if it was simple, help wouldn't be needed from anyone. But the size of it doesn't mean you can't do a lot of important things. Keep your eyes open. Start by looking for ways to help. Nothing major at first. Just look, listen, investigate. Think about what small things you can do that might help a little bit, then do it. Then look for the next little bit within your reach. The key is don't make the mistake I did of thinking that the problem is so vast, I could never make a difference. So how did I get over the hurdle? Truthfully, I heard something that I now call the Starfish Story, and it gave me a whole new perspective on change, and I'll share it with you. It's very brief. It's apocryphal. It's about a little boy on an East Coast beach. It's low tide. There's starfish on the rocks drying, and he's picking up starfish and throwing them back in the water. And an old man comes up and he says, "What are you doing, son?" And he says, "Well, I'm saving starfish." And the old man says, "Look down the beach. There are millions of them. You can't make a difference." And the little boy ignored him completely, as little boys often do. And he picked up a starfish, dropped it in the deeper water, and he smiled and said, "It made a difference to that one." And I think that's really what lit my fire. I realized I didn't have to fix the whole world, and certainly not all at once. I embraced the idea that I could do a little bit, one starfish at a time. And then everything from there evolved in ways I'd never even imagined. It became sort of a snowballing effect. And so I started by committing to doing something small, and then I basically became amazed as an evolution of things unfolded. So in my case, I started by looking into the problems. And by the way, believe it or not, when you get to this point, you're past the hard part. You really are, because all you need to do is go and find where the problems are being dealt with. In my case, it meant looking into where animals were being abused near me, what things were being done. You can do exactly the same thing. What is the actual problem? Who's working on it? Are there people nearby, groups, government entities? Where are they working on it? How are they addressing the issues? Do they meet? Do they meet close to you? With Zoom, you can certainly get involved that way. And once you figure that out, you start to talk to the involved people, attend some meetings, and you quickly find like-minded people who help educate you. Listen, learn, ask them what's happening, what the real problem is, and what do they need. And it's interesting because lawyers analyze problems differently than other people, often in a way that uses skill and training that they didn't have before they went to law school and began practicing. So apply your legal skills to the analysis of the problem. Figure out what's really broken and how maybe you can help. And usually, before I ever got a chance to offer any ideas, people learned I was a lawyer and started asking me for legal advice. And I can imagine why they would. Lawyers are expensive. And if they've got somebody there offering their time and volunteering who loves their cause, what a coup. So almost always the organizations or people involved need some kind of assistance. Maybe they're a business of some type, a nonprofit. They often need legal basics for sure, contract issues, insurance questions, sometimes landlord-tenant disputes, employment issues, even business formation or planning, and unfortunately, sometimes even litigation. But I learned that my training helped me figure out what was really needed because, as you know, clients don't always know what they need. In my case, as I got deeper into the issues, knowledge of animal law became important. So I researched. I reached out to lawyers to ask questions who were involved in it. And I soon found that there were plenty of ways I could help. There weren't enough lawyers involved. And that led me to become involved in writing new animal-related laws and testifying in Sacramento in support of animal-friendly litigation. Helped me working with local governments. In one case, I mediated a case for the county of LA, pro bono, of course, settling a dispute filed by an animal advocacy group. And I had one foot in both camps, and I think both parties knew it. And the settlement in that case produced sweeping changes, improving the lives of captive animals. And so when things like that happen, your confidence grows, as does your ability to help. And that in turn helps you find and get involved in bigger and more exciting things. So I found along the way a problem that I didn't see coming, because I was thinking it was a great blessing. In most instances, people were hiring me once they had a legal problem, and I was getting a twofer. I could represent people and get paid for that and get paid for my day job. But I soon realized that my desire to help animals conflicted with my desire to get paid by people. And that is because the cost sometimes of providing the legal work got to be too much. How much can an owner pay to save their Labrador retriever? And they would give up on their dog or cat or goat or horse or whatever it was, and the animal might be euthanized. And so after I ran into that wall a few times, I realized it was just too painful for me and better for my real clients, the animals, if I provided my work pro bono. And that way I could help the animals without placing financial pressure on conflicted owners. And that helped me a lot. At first, my partners did not love it. And I just told them, look, I need to do this. This is something I really want to do, and I'll work harder on my other stuff. And I think I can fairly say I never became one of the billers that was not close to the top of the line. I just put my time in separately for animal work. And I ended up taking on bigger cases without fear I would be undercut. And as I did that, I got more and more clients, and I had to actually narrow my pro bono practice. So no big surprise, if you offer free legal advice, you might get a lot of clients. But in the case of animals, it's not necessarily that obvious, but it turned out to be true there too. So I decided to prioritize my favorite causes, and that happened to be large mammals like elephants, whales, wolves, gorillas. And I have to say, at the idea of that, I have to laugh a little, because I never even knew at that point how to see one of these clients, much less how to help them legally. But after years of work helping mostly small animal people and their pets, I found myself in litigation against the LA Zoo over decades of long abuses to Billy and the other elephants at the zoo. That case lasted almost 8 years pro bono. We had a novel theory thrown out, reversed on appeal. We won at trial, went all the way to California Supreme Court, reversed on a non-animal related technicality, never even raised in the lower courts. So next lesson, be prepared for setbacks. You do your best, but then you have to do your best not to get discouraged. Again, if fixing the problem was easy, it wouldn't be a problem. So don't give up. And as things developed, probably due to that case, and it was fairly high profile at the time, I was asked to represent other organizations like the Gorilla Foundation in Northern California, where Coco lived and learned sign language. And I was asked to represent the whale rescue team here in Los Angeles and speak at various animal events, and eventually join the boards of various organizations, one of which is the Whale Sanctuary Project, which is working to open an ocean sanctuary in Nova Scotia for rescued orcas and belugas. I'm also on the board of the Wolf Connection here in LA. All starfish rolling along that I never even knew about, much less had an opportunity or considered that I could get involved at that level. But as things happen, I was also presented with an amazing opportunity traveling in Cambodia, and I seized that opportunity to form my own nonprofit organization with a partner friend of mine in Cambodia. Too long a story to share here. I'm happy to share it offline if anyone's interested, but let's just say it was a very big starfish and I leaped at it. And 20 years later, the Cambodia Wildlife Sanctuary, which was conceived and we founded, is still hard at work, and we're rescuing elephants, primates, and other indigenous animals. And you probably heard about the most recent rescue. In fact, Jake mentioned Cher. Well, the real Cher was made a lot of news rescuing a bull elephant from Islamabad, Pakistan. His name is Kavan. He was transported to the Cambodia Wildlife Sanctuary. And so we're building out his quarters right now for a larger area. Given that success, we're trying to go back and convince the city council to release Billy the elephant so we can fly him to Cambodia to join Kavan. And yet one more chapter is unfolding. On behalf of Cambodia Wildlife, we've got a streaming service that we're opening called EcoFlix to stream wildlife films. People who subscribe will get a tax-deductible donation. We're going to share half our revenue with the filmmakers. The NGOs that promote will get the first month of revenue. It's a huge giving back circle. Jane Goodall, Sir David Attenborough, and many others are involved with us. And I think it's going to be a really good effort. And all of these things happen one by one, just by being open to the possibility. These things sort of fell in my lap, if you will, saving one starfish at a time. And you can do the same thing. I never expected to get to this point. And so the pitfalls that you really need to watch out for are take it slow. As Pat was talking to you earlier, don't dabble. Don't offer legal advice when you don't know what you're talking about. It's an area, whatever area you choose, make sure that it is something that your employer, if you're employed, allows you to get involved with. Research the law, take CLE courses to give you subject matter expertise. But always consider how your volunteer work might impact your career. Not only should your employer know, some clients might need to know, depending on the nature of your work and their case. And so if your employer has limits on whether you can do that in your free time, you may need to change your employer or change your pastime. Your private activities could potentially trigger their malpractice insurance. Get permission. Don't use your employer's name or resources without approval. Be thoughtful about what you say because it could negatively affect people that you work with, clients, employers, positions taken in court. Always be honest about your level of experience. Like Pat said, that particularly applies here. People will assume because you're a lawyer, you must know everything about the law. And they probably will unless you tell them otherwise. You don't have to know everything. So just look at the bright side. Work to make change. Do it a little at a time. Find like-minded people, including not just clients. You might find your opposing counsel and even judges are interested in the same things you are. Don't be surprised if you forge deeper professional relationships or thaw the ice with opposing counsel when you learn you share common social interests. So find your passion, indulge it, do good things for the world. You'll benefit emotionally and hopefully save many starfish along the way. And if you get stuck trying to make a difference, you run into issues or you just need some inspiration, feel free to reach out to me. I'll do my best to help smooth your pathway. And thank you all for the great things you're soon about to do.
Well, thanks, David, for those comments.
Really amazing, David. You're a great person. You know, it's really, no, it's touching. It's really powerful.
I think that's absolutely correct, David, and you've done a magnificent job. I only have one criticism. When we prepared for this session, you had that photo of the elephants behind you that I thought was much more impressive than your bookshelf.
Well, I'm not sure what photo you're talking about, Pat, but it's possible that it might be available. You mean something like this for EcoFlix or?
I'm guessing you've got a few.
Yeah, I got a few. Anyway, I think we're pretty much out of time.
That's right. Thank you, presenters, for that wonderful presentation.